Good afternoon, Section Zoom. This is Dean Beck, recording from our secret above ground bunker in Oconee County at the Beck family compound out here. I hope you guys are all doing well. One note on the end of the last lecture in the chain of title materials, on pages 446 to 49 in the book, there are some fairly complicated chain of title problems. I am not going to expect you to know that material for the exam. If you want to work through it and would like my input on how to answer the problems, I'm happy to give it, but don't worry about that for exam purposes. That's kind of a level of complexity beyond what I'm hoping that you all pick up for purposes of this course. But now it's time for us to talk about the material starting on 449 and following about who is protected by the recording system. What does it take to be a bona fide purchaser, and which people establish that status in a way that provides protection to them. And the case that we are given to look at on this is Lewis versus Superior Court. So let me pull up just kind of the facts of the case, the timeline that you need to have to understand what's going on in the case. So Lewis versus Superior Court. It starts with February of 1992, the Lewises signing a contract to purchase a house from Shipley out in California, probably no relation. Then February 24th of 1992, a company called Fontana files a document called a Liz Pendens. If you remember from earlier, Liz Pendens is just basically notice of a lawsuit that affects title to property and that you want people potentially purchasing the property to take into account. So Fontana files that on February 24th. The next day, the Lewises on February 25th pay $350,000 to Shipley as a down payment on the house. Then 3 days later, February 28th of 92, you have the closing. And at closing, the Lewises receive title from Shipley, and they give Shipley a promissory note for the balance of the purchase price, the other $1.95 million that they still owe. The day after closing, on February 29th, 1992, Fontana's Liz Pendens is indexed in the recording system so that it can actually be found by a title searcher. The next month, sometime in March of 1992, the Lewises pay off the other $1.95 million that they owe under the promissory note. And then a year and a half later or so, Fontana sues to try and enforce their rights under the Liz Pendens, and that is the first that the Lewises actually learn of the existence of that Liz Pendens is when that lawsuit is filed. So the question here is whether and to what extent the Lewises are protected by the recording system. The assumption of the case is that they are subsequent purchasers because they made their purchase after the filing of the Liz Pendens. And so the question is, can they get priority over Fontana's interests or rights in the property by virtue of California's race notice statute. So they have to show that they took their interest in the property without notice and that they recorded first. Now, what about the fact that the Liz Pendens was actually filed before the Lewises paid anything to Shipley? Does that prevent them from claiming that they are bona fide purchasers? Does it mean that they had constructive notice of Fontana's interest in the property? And the court decides, no, that doesn't give them constructive notice because it's not until February 29th, 5 days later, that it is actually indexed. So that is the point at which a title searcher could actually find the Liz Pendens. And so on February 24th, just the fact that it had handed it to court officials, that was not enough to give constructive notice to the Lewises. This is an issue that is dealt with in the book on page 426, note 1. Different jurisdictions have different rules on whether indexing is part of the recording process. In other words, whether you can have notice of a document before it makes its way into the index. So the Lewises don't lose on the ground that Fontana actually had filed the Liz Pendens before they paid any money. But Fontana makes another argument. He makes the argument, or Fontana makes the argument that the Lewises are not protected as bona fide purchasers because actually most of the money that they paid on the house was paid after the Liz Pendens was indexed and could have been found by a title searcher. So maybe we can concede that as to the first $350,000 that they paid to Shipley, they didn't have notice of Fontana's interest. But certainly Fontana argues by the time they paid $1.95 million on the promissory note, at that point, they certainly had at least constructive notice of Fontana's claim, and they should not be allowed to claim the bona fide purchaser status as to that payment that they make. Fontana relies upon an old California Supreme Court case called Davis versus Ward, decided in 1895. And just to kind of understand the argument they're making, let's see if we can trace out what happens in Davis versus Ward. So in Davis versus Ward, Ward grants a mortgage on some property to Davis's predecessor. That mortgage is recorded, but unfortunately it's improperly recorded. It's recorded against the wrong property, so that somebody who was searching for the land in question here that the mortgage was supposed to attach to would not find it. So Ward then, even though there's a mortgage that's been unpaid, turns around and sells the property to two people called Fleming and Brown, and they're not situated exactly the same. Fleming pays for his half all in cash. Brown doesn't have cash or doesn't pay all cash. Instead, Brown gives a $200 down payment in cash and then gives Ward a promissory note for the balance of the money that Brown owes. So Davis steps in and sues Fleming and Brown, trying to claim that that they are not protected by the recording statute, and that suit gives them actual notice of the mortgage that is held by Davis. Case makes its way up to the California Supreme Court, and they're trying to decide, were Fleming and Brown bona fide purchasers protected by the recording statute? Well, Fleming wins. He is a bona fide purchaser because he paid all of his money that he was paying towards his interest in the property before he got notice of Davis's mortgage. But the case against Brown comes out differently. The court observes that he did not pay all of the money before he got notice, that in fact he'd only paid $200 and given a promissory note to Ward, and at that point he got actual notice of Davis's mortgage when the lawsuit was filed, and so he was not a bona fide purchaser with respect to the payments, to any payments after that point. And so the case against Brown is remanded. And Fontana, in the Lewis case, says, well, I am really like Davis, or we are really like Davis in the Davis versus Ward case, and the Lewises are really like Brown. Like Brown, the Lewises paid a little bit bigger down payment, $350,000 versus $200. And like Brown, they gave a promissory note to the seller for the balance of the purchase price. And therefore, since Brown loses in Davis versus Ward, then the Lewises should also lose here, and we should win like Davis did in that older case. And so the case goes up to an appellate court in California, and that court has to decide, well, do the Lewises lose because the court is bound by the case of Davis versus Ward? So one side note is the question of whether the Davis court would have come out the same way if Brown had paid $200 down and then given a promissory note to a bank that financed the rest of the purchase price. And if you look at the opinion on page 452, the last paragraph, the court there suggests no, that if the purchaser gives a promissory note to a bank that finances the purchase price, then the purchaser is treated as having given full value for the property. So that situation, you're a bona fide purchaser if you finance through a bank and use a promissory note in that context. But here, where the promissory note is to the seller of the property, the question is, does Davis require a judgment in favor of Fontana here? And the California Appellate Court decides that the Lewis's win here, and that Ward versus Davis, or Davis versus Ward, does not compel a contrary outcome. They don't seem to like the Davis versus Ward decision very much, and so they limit it to its facts. They think it is inconsistent with kind of modern real estate practice. They say we don't really know all that we need to know about the case. For instance, we don't know what remedy the court imposed on remand. It could be that the court decided on remand that Davis should just step into the shoes of Ward, the holder of the promissory note, and that Brown should make the remaining payments on the promissory note to Davis rather than to Ward. That's perfectly consistent with what we read in the opinion. But in any event, the court says Davis versus Ward does not apply here because of the form of notice that is in question. So in Davis versus Ward, before paying the balance of the purchase price, paying off the promissory note, Brown had actual notice of Davis's claim against the land. But here, the Lewises did not have actual notice of Fontana's Liz Pindon's at the time that they paid off the promissory note to Shipley. At that point, the best you can argue is that they had constructive notice, that if they had done a title search in March of 1992 before they paid off the $1.95 million to Shipley, if they'd done a title search at that point, they would have found out about Fontana's Liz Pindon's. And the California Appellate Court in Lewis says basically, constructive notice is not good enough in these cases. That if you say that any payments after constructive notice are not protected by the recording system, then basically when somebody buys a house with kind of a down payment and then monthly payments, they have to do a title search every month before they make their payment to find out if there is some other interest in the property that they need to take into account in deciding whether to pay. That would be an unreasonable burden. And so the court decides that at least Davis versus Ward should be limited to the extent that it would only apply if a person has actual notice before they pay the balance of the purchase price. Constructive notice is not good enough. Now, there are a couple of notes after Lewis versus Superior Court that I wanted to call to your attention. Let's see. All right, so go down to page 453. The first note has to do with creditors, and it's interesting to see the different rules about when a creditor gets protection under the recording statutes. But notice particularly note 2 about quitclaim deeds. The authors tell us that in a few jurisdictions, if you get your interest in the property by a quitclaim deed, you cannot claim to be a bona fide purchaser without notice. And so the idea there is, well, quitclaim deeds are kind of suspicious, right? Why is this seller of property not willing to warrant that they actually have title to the property? And so those jurisdictions seem to think that the quitclaim deed itself is enough to kind of create some form of notice for the purchaser that they may not be protected, that there may be some outstanding interest against the property. But notice that a large majority of jurisdictions don't take that view. There are lots of reasons somebody might use a quitclaim deed, and so by itself, it should not defeat your status as a bona fide purchaser.